It was 25 years ago this week that Clarence Thomas took the oath to serve as an Associate Justice of the Supreme Court. He was asked once, some years ago, how he evaluates his own time on the court. And he took that opportunity to reflect back on the oath that he took back in 1991. He had this to say. He said, "In my years on the court, I have looked at my clerks at the end of every term and asked, have we ever stepped beyond our assigned roles? And the way I do that is with the oath. I look these kids in the eye much the same way that my grandfather would look at my brother and me and ask, was there one time that we shied away from doing our job? Was there one time that we did anything improper with the authority that we have from the Constitution of the United States? And I can say to you that in my tenure, we have never gone beyond our role, and we have never, ever shied from the duties that are required of us under this Constitution." That's an interesting window, I think, into Justice Thomas's sense of the judicial duty. As Michael suggested, Justice Thomas's quarter century on the court has been marked by what Professor Ralph Rossum has called a clear and consistent jurisprudence of constitutional restoration. He's written his share of majority opinions, but that restoration project has taken shape, I think most would agree, in the form of some 390 concurring and dissenting opinions that he's written, charting the path, sometimes a lonely path, to the original meaning of the Constitution as Justice Thomas understands it. With us to explore that impressive body of work, we have a panel of accomplished lawyers, three of whom clerked for Justice Thomas, all of whom are astute observers of the court. At the end of our table, we have Greg Katzis, who is a litigation partner at Jones Day. Greg previously served in leadership positions at the Department of Justice, including as an Assistant Attorney General for the Civil Division. A graduate of Harvard Law School, Mr. Katzis clerked for Justice Thomas both on the D.C. Circuit and during the Justice's first term on the Supreme Court. Next is Professor Nyomi Rao of the newly renamed Antonin Scalia School of Law at the George Mason University. She previously served as an associate counsel and special assistant to President George W. Bush and as counsel to the Senate Judiciary Committee. A graduate of the University of Chicago Law School, she clerked for Judge J. Harvey Wilkinson on the Fourth Circuit and for Justice Thomas. Jeff Wall co-chairs the appellate litigation practice at Sullivan and Cromwell. Before entering private practice, Mr. Wall served as an assistant to the Solicitor General, arguing many cases before the court. After graduating from the University of Chicago Law School, he too clerked for Judge Wilkinson and for Justice Clarence Thomas. Finally, we have Elizabeth Wydra, who this year took over as president of the Constitutional Accountability Center after serving for 8 years as the center's chief counsel. Previously, Ms. Wydra was an appellate lawyer at Quinn Emanuel and a teaching fellow at Georgetown University's Appellate Litigation Clinic. A graduate of the Yale Law School, she clerked for Judge James Browning on the Ninth Circuit. Just a quick word on format. We have no hope of covering the waterfront of issues that Justice Thomas has tackled. Instead, our panelists are going to begin by each addressing a particular area of the law that exemplifies Justice Thomas's unique approach and the unique mark he's made on our law. Greg will speak to Justice Thomas's critique of the court's Commerce Clause jurisprudence. Professor Rao will explore Justice Thomas's reexamination of the powers of the administrative state. Jeff will address Justice Thomas's First Amendment jurisprudence, and Elizabeth will discuss his attempt to recover the original meaning of the Privileges or Immunities Clause of the 14th Amendment. I will then kick off an exchange among the panelists on a broader set of subjects before opening the floor for questions from the audience. And with that, I'll turn to Greg.
Thanks. So we have divided the docket by subject matter, but I thought I would begin with just a couple of overview points, hitting some of the highlights of Justice Thomas's jurisprudence and themes that will run through all of the cases and all of the areas that we'll be discussing. So first and foremost, he is a textualist. He views his job as figuring out the meaning of specific words that constitute the law that is his job to enforce and apply. And so you see in his opinions are long on arguments about what words mean, about the structure of the provisions before him, about canons of interpretation, and short on more open-ended arguments about purpose and policy and the like. Second, he is an originalist. So he is trying to figure out not the meaning of the words to the current day readers, but to the people who wrote the law. And in the case of the Constitution, some 200 plus years removed, those can be very different. And so his opinions are long on history and short on evolving standards, to borrow a phrase from the Eighth Amendment law. In those respects, he is very much like his friend, the late, great Justice Scalia, but in some other respects, he's actually somewhat different. The Lone Jurist, who is the subject of this panel, is somewhat different from a justice who famously described himself as a faint-hearted originalist. So Justice Thomas takes a narrow view of stare decisis. He is much more inclined than his colleagues to ask himself, what is the right answer, as opposed to what do recent decisions suggest. He's also much more willing than his colleagues to go it alone. And this is not just a personality preference or quirk. This is really fundamental to how he views his judicial oath as an individual responsibility running to him to call things as he sees them, and that prevents him from going along to get along and compromising so that the court can speak with one voice, as opposed to him speaking, interpreting and applying the law as he sees it. And finally, the scope and sweep of his opinions, he thinks and writes broadly. He is very, very willing, if he sees an area of law that he thinks is misconceived, to question it and attack it root and branches, and not to pursue problems by nibbling at the outer edges one case at a time in the sort of minimalist approach of, say, a John Roberts or a Sandra Day O'Connor. So, the Commerce Clause. The big separate Thomas writing in this area, of course, is the Lopez case. That's the case on whether Congress could prohibit possession of a firearm near a school. The key precedent at issue in Lopez was, of course, Wickard versus Filburn, the Commerce Clause case that conservatives most love to hate. That's the decision in which the New Deal Court said that Congress could use its Commerce Clause power to prohibit a local farmer from growing a little bit of extra food to feed his family. No commerce involved and nothing interstate involved, but the court reasoned that, well, if every farmer who wanted to grow a little bit of extra wheat to feed his family did so, there would be a substantial effect on interstate commerce in the aggregate, and that's good enough for government, and they uphold the prohibition on that reasoning. Now, if you were inclined to sort of follow precedent and take things as a given, you would ask yourself, in Lopez, should we apply Wickard or not with regard to possessing and growing wheat to possessing a handgun? And the majority opinion, which Justice Thomas joins, frames the question that way, answers it no, says that, well, growing wheat it's not commerce, but it's at least economic activity in the way that possessing a gun isn't. And so you don't need commerce and you don't need anything interstate, but at least you need economic activity, which is sort of like a light form of commerce. And they limit or at least decline to extend Wickard in that way. Justice Thomas, as is characteristic, thinks about the problem a little bit more broadly. And he writes a solo concurrence in which he starts from first principles. And he takes the Commerce Clause and basically treats it as any other legal text to be interpreted, and brings all the traditional tools to bear on that question. So he starts with text. Right, you need commerce, and he says commerce is an exchange of goods and services. It's not manufacturing, it's not production, it's not growth. And then he looks at constitutional structure and makes all the obvious arguments for a limited commerce power. He says the act of enumeration, right, there are limited enumerated powers of Congress, presupposes that there are things not enumerated. He looks to the 10th Amendment, which would be surplusage if the commerce power were infinite. He says, well, if the power to regulate commerce was the power to regulate anything affecting interstate commerce, a lot of the other enumerated powers would be wholly superfluous. Why would you need a bankruptcy power, for instance? And he says that if you really took seriously this doctrine that a power to do something extends to a power to get at anything that affects that, you'd get crazy results. And so just think of the president's enumerated power as commander-in-chief, right? He gets to conduct wars. Do we really think that means he gets to control everything that could substantially impact the conduct of a war? If the answer to that question were yes, then he could obviously seize and run the steel mills, which nobody thinks he can do. He then runs through the history and demonstrates that the founders, in fact, did understand the Constitution in the way that all of these textual and structural arguments would suggest, that the power to regulate interstate commerce means regulate interstate commerce, not local activity that might somehow affect commerce. And then and only then does he address the question of precedent, having done all this work, can make the case that the court has gone badly astray, and in response to the dissenters' arguments that they have 50 years of precedent on their side, he can say, well, you might have the last 50, but I have the first 150. And that's how he frames the issue. And then the sort of ultimate formulation that you see in so many of these opinions is, we can decide this case narrowly, but we should reconsider more broadly this whole enterprise. And so he's taking the long view. He is expanding the range of reasonable debate. And it's hard to predict what's going on in the minds of other justices, but I think by framing the issue that way, he might actually make it easier for centrist swing voters who would never join an opinion like that to actually come out in favor of the sort of incremental cutbacks that one sees in cases like Lopez and Morrison and NFIB than might have been possible if the other side had framed the debate more conventionally as just, does Wickard apply or not apply to possession of guns in the way that it applies to possession of wheat. Let me close on the necessary and proper clause. Similar story here. If you looked at recent precedent, you would conclude that Congress can do pretty much anything under the Commerce Clause, but if there's anything it can't quite do under the Commerce Clause, it can surely do under the Necessary and Proper Clause, which makes the Commerce Clause and other powers even broader. Justice Scalia, of all people, had seemed to adopt this view in the Raich case, the medical marijuana case in 2005, which made the Thomas position even more challenging on necessary and proper than maybe it had been on the Commerce Clause. So Justice Thomas writes two important opinions in this area. One is Raich, where he's all by himself in dissent, going beyond the principal dissent of Rehnquist and O'Connor. And then in a case called Comstock with Scalia, in both opinions he's trying to reconstruct the original meaning of the necessary and proper clause. And he makes all the basic points that one might make building on McCulloch versus Maryland, the famous original case on that topic. And he says, you need a legitimate end. Congress can't use its necessary and proper power as a pretext. You need a reasonable fit between means and ends, and courts can look at those kinds of principles. Congress can't use the necessary and proper clause to subvert other limitations in the Constitution. And then perhaps most original and most important, he says, the necessary and proper clause is an ancillary power. You can't, whatever it means, you can't let the tail of the necessary and proper clause sort of outgrow the dog of the Commerce Clause. And then the last case I'll mention, NFIB, the challenge to the individual mandate in Obamacare. The government defended the individual mandate primarily on necessary and proper grounds. It said, well, the mandate is necessary to make all of these crazy insurance regulations work. Because if we just had the insurance regulations forcing insurers to not charge more to higher risk people, the system would collapse on its own weight. In order to make those regulations effective, we have to be able to make other people buy insurance. If you just looked at the verbal formulation from Scalia in Raich, you would say, well, that's a pretty good argument. It didn't prevail. Actually, the 5 justices held that the necessary and proper clause was not an adequate basis to uphold the mandate. The Thomas view, the narrow Thomas view from Raich and Comstock prevails over the broad Scalia view from Raich, and the necessary and proper clause is limited. Of course, the court then rewrote the mandate into a tax to uphold it on that basis, but that is another story.
Okay, so I'm going to focus on Justice Thomas's administrative law decisions, and I want to just talk a little bit about how he is really fundamentally rethinking the legal foundations of the administrative state. And the decisions in this area draw on many of the themes that Greg already mentioned. They draw on the text of the Constitution, its original meaning, and very much on first principles. But perhaps just to frame these decisions, I think I'm going to just say a little bit about where the current doctrine is with administrative law, just so you can have a sense of how revolutionary some of his opinions have been. So sort of from a very high level, it seems to me that the administrative state is supported primarily on 2 legal pillars. The first being the non-enforcement of the non-delegation doctrine. Right? So the Supreme Court essentially has allowed Congress to delegate all sorts of authority to administrative agencies and looks only to see if there's an intelligible principle. That's the test that the court has been using since 1928. And almost anything can fly as an intelligible principle, and that has left administrative agencies with an awful lot of discretion. I'd say that the second main pillar are all of the related judicial deference doctrines. So, so when statutes are ambiguous or silent, the court will defer to reasonable agency interpretations under Chevron. And they also will defer under Seminole Rock and Auer to an agency's interpretations of their own regulations. And the net result of these 2 doctrines, very sort of broadly considered, when you combine open-ended delegations with judicial deference, what you have is a substantial expansion of executive power. And agencies do exercise a tremendous amount of power, arguably outside the boundaries of the Constitution. And in 2 remarkable separate opinions in the spring of 2015, Justice Thomas, I think, he really goes after both of these pillars and really kind of gets at the foundation of them. And I want to start with his rethinking of the non-delegation doctrine, because it strikes me that this is the most revolutionary aspect of what he's doing. Because if you talk to most scholars or most lawyers, everyone assumes that delegations are essential for our modern government to function, that it would be impossible to have a modern working federal government without delegations. And so questioning these delegations and arguing for more judicial review over delegations is a potential sea change. And this is a context, so Justice Thomas first laid down a marker on the non-delegation doctrine in 2001. He wrote a very short concurring opinion in American Trucking versus Whitman. It was just a couple of paragraphs, but there he questioned whether the intelligible principle standard could really adequately protect delegations. And he said there, very, very briefly, he said, "The Constitution does not speak of intelligible principles. Rather, it speaks in much simpler terms. All legislative powers herein granted shall be vested in a Congress." Right? It's Article 1, Section 1. All legislative powers are vested in Congress. And so then in 2015, we have Department of Transportation versus the Association of American Railroads. And the issues in the case, I'm not going to get into all of them, but they were related to the constitutionality of delegating a form of rulemaking authority to Amtrak and the Federal Railroad Administration. And the majority essentially avoided the delegation issues and held that Amtrak was a governmental entity. So they didn't really get to the heart of the matter. And Justice Thomas wrote an opinion concurring only in the judgment where he began with first principles and set out a much more elaborate view of how courts could begin to rethink the delegation doctrine. And he starts in a very, the first principles are always sometimes, always the best. He says, the Constitution identifies 3 types of government power: legislative, executive, and judicial, and it vests them in 3 distinct branches. And then those branches have to exercise their powers under the particular constraints and limitations imposed by the Constitution. And he recognizes that although the powers are distinct, sometimes the branches will exercise similar functions. So Congress enacts laws under the legislative power, and the executive branch obviously has some authority to fill in gaps or to make rules, although it's a much more limited grant of power. And so, but he says what's at issue in this Amtrak case is, he calls it the formulation of generally applicable rules of private conduct. And he says when that is what's at issue, when you're talking about generally applicable rules of private conduct, that must be exercised by Congress because it must be exercised through the legislative power and through legislative processes. And so the executive branch has discretion, and they have some gap-filling discretion. They can make rules under delegated authority, but their gap-filling authority, their executive power, doesn't extend to the formulation of these types of rules. And then he roots this idea in separation of powers, and he talks about how the separation is essential to the rule of law. And he traces this through English history and talks about political theory, John Locke, and explains, why this framework was so important to the founders of our Constitution, and how separation of powers is not just a theoretical idea, but it's an idea essentially linked to individual liberty. And Justice Thomas is not, sometimes you'll say, oh, he's so abstract, he's, writing out here, but he's also understands that there's certain realities about government. He recognizes in his opinion that it is difficult sometimes to draw a line between legislative power and executive power. And that's certainly the reason the court gives for its current non-delegation doctrine. They say, well, we can't figure out what's legislative or executive, and so we've just given up. And, for Justice Thomas, that's not good enough. He says, look, it may be elusive. The line may be elusive, he says, but it is no less important for its difficulty. And, this goes to the responsibility of the judge, right? It might be hard to do, but he believes that he needs to find, that judges need to try to draw this line, that this line is an important one to separation of powers and to the structure of our federal government. So he concludes then that the intelligible principle test doesn't protect the Constitution's vesting of all legislative powers in Congress, and that the rules of private conduct can only be created through the legislative process. And he rejects the arguments from necessity. So the Supreme Court said in an earlier non-delegation case, Mistretta said Congress simply cannot do its job in a modern complex society without delegation. That was the view of the majority of the court. And Justice Thomas points out, well, enforcing the non-delegation doctrine, may not be very efficient, but as we know, our constitutional structure is not designed for efficiency. It's designed to protect individual liberty. And I just wanted to read what he wrote at the end of this separate opinion, because I think this very much captures what the case is all about. He says, we have overseen and sanctioned the growth of an administrative system that concentrates the power to make laws and the power to enforce them in the hands of a vast and unaccountable administrative apparatus that finds no comfortable home in our constitutional structure. The end result may be trains that run on time, although I doubt it. But the cost is to our Constitution and the individual liberty it protects. You can see here, Justice Thomas is, he's breathing new life into this principle that the legislative power cannot be delegated in our constitutional system, and that courts have to draw some lines. Okay, I don't have too much time. So let me just also mention his other concurring opinion from that same term, Perez versus mortgage bankers. And in that case, he's fundamentally rethinking the seminal rock and hour deference, which is the deference that's given to an agency's interpretation of its own regulations. And, he says, look, there are basically two main problems with this type of deference. He says, first, it transfers judicial power to the executive branch, right? The power to interpret is being left to agencies. And then second, it erodes the judiciary's check on the executive. And he explains in some detail why those two principles apply in this context. And although, Chevron deference, or really the main form of judicial deference, isn't at issue in the Perez case, I do think the reasoning of his decision very much also cast doubt on Chevron deference. So in these two cases, he's really attacking what I've said is the two fundamental pillars of the administrative state. And so we'll see what happens going forward. Thanks.
So first, I want to thank the Claremont Institute and the Federalist Society for hosting this event and inviting me to be a part of it. It really is a pleasure to be up here with Brian, Greg, Nyomi, and Elizabeth, especially in this building on this 25th anniversary. When I clerked for Justice Thomas a little more than a decade ago, I think his influence on the court at that time was almost criminally underestimated by the academy, bench, and bar. In the last decade, and in particular in the last 5 to 7 years, I think that has begun to change as people have taken deeper, richer, and more nuanced looks at his jurisprudence. But from time to time, you will still hear someone say or see in print the pernicious and wrong-headed claim that he has not been an influential justice because he has not cobbled together majorities and written major majority opinions in lots of areas. You can dispute whether or not that's true, but I think what it misses is his value as an intellectual catalyst. He is a man who would prefer to sow, even if others will reap, and I don't think that's been more true anywhere than in the context of the First Amendment, and particularly the speech clause. I can't cover, and I apologize for my voice, I'm getting over a cold, but I can't cover all of his opinions in just a few minutes, but I wanted to just offer a few kind of high-level thoughts. I think the conventional wisdom is that Justice Thomas is as speech protective as any of the members of the current court. And I think that's right, subject to a pretty important caveat, which I'll talk about on the back end, which is that where he believes that the First Amendment applies, at least with full force, he gives as broad a scope to the speech clause as anyone on the court. He has a very robust vision of what the speech clause protects. So last year in Reed v. Town of Gilbert, writing for the court, you find Justice Thomas saying that facial content-based restrictions on speech, so restrictions that say you can talk about one thing but not another, some subjects but not other subjects, that those kinds of restrictions on speech get strict scrutiny, which is the highest level of scrutiny and which is often fatal to the law under review. He is deeply skeptical of the notion that the government should be able to play favorites either as among speakers or as among subjects or messages. Now, you might think, look, what's so controversial about that? Of course, content-based restrictions on speech across the board should get strict scrutiny. But what about restrictions on commercial speech? It was Justice Thomas in the mid-1990s in the Liquor Mart 44 case who was the first to say that content-based restrictions on commercial speech should not get any lesser degree of scrutiny than content-based restrictions on political speech. Now, the court has never gone that far, but if it's serious about what it said in Reed, then it may well. And if it does, it will be Justice Thomas that sowed the seeds for that decision. In the campaign finance area, in his Colorado Republican 1 concurrence back in the mid-90s, he attacked Buckley v. Vallejo's distinction between contributions and expenditures. And then in the Missouri shrink case, he launched an all-out attack on the entire framework of campaign finance laws, laying the groundwork, I think, for decisions that culminate in Citizens United. So those are two areas, but you also could think about anonymous speech in the McIntyre case, or broadcaster's speech. He was the first, and I think the only one to date, to call for the court to re-examine cases like Red Lion and Pacifica that allow the government to place limits on broadcasters. In area after area where he thinks the First Amendment applies, he has taken an incredibly robust view. But the caveat is an important one. In looking at the history of the First Amendment, Justice Thomas is not of the view that it applies across the country in every context with equal force. So think of prisons. In 2003, in Overton v. Bezzetta, I think he was the first, at least on the current court, to say, joined by Justice Scalia, that constitutional rights, including the First Amendment, apply with diminished force inside prison walls. In the Morse v. Frederick case in 2007, he says the same thing about schools. He calls for the court to overrule Tinker. He doesn't think that students have a First Amendment right to speak freely inside of schools based on the history of the First Amendment. In the Brown v. Entertainment Merchants Association case in 2011, that's the violent video games case, he says, look, I'm looking at the history of the First Amendment. I don't see a First Amendment right to speak directly to minors without going through and obtaining the consent of their parents or guardians. I just don't see it in the history of the clause. He's in dissent there, but that's his view. Government employees. He has been, I think, skeptical of First Amendment employees, First Amendment protections for government employees. He does not think that they have a full right to express their views, at least in their capacities as public employees. And government speech. He's taken the view that when government itself is speaking, that the government should be able to say what it pleases, free of a number of restraints in the First Amendment. And that's caused him to line up in some controversial cases. Think about last year in the Confederate Veterans License Plate case. He lined up with the liberal wing of the court. He viewed those license plates as government speech. Now, I think it's fair to debate whether motorists in Texas seeing those license plates would really perceive those to be speech by the state of Texas, but that's the way he saw it. And having seen it that way, there was no doubt in his mind then that the state of Texas was free to say what it wanted, even though he broke with the conservative wing of the court in delivering that view. So I think the bottom line is that he is a remarkably speech-protective justice in contexts where, looking at the history of the First Amendment, he thinks that it applies. But he has been very faithful to undertaking a sort of threshold inquiry on what the history in a given context is without reflexively applying the First Amendment in the absence of that sort of deeply historical inquiry. That's the past. I'll kind of leave you with one thought for the future, which, this is, I think, where he's going, or maybe where he's going. In the abortion case from this past term, Whole Women's Health, if you read one thing by Justice Thomas, you should go read his opinion, and here's why. Not for the abortion reasoning, but for this. He talks about the tiers of scrutiny, and he's talking about it in the context of the 14th Amendment, but it applies equally to the first. Strict scrutiny, intermediate, rational basis, these sorts of tiers. He says, look, these tiers are basically made up. They're not in the Constitution. You find them nowhere. He says, that's a problem enough, but the problem now goes beyond that. If our recent cases illustrate anything, it's how easily the court tinkers with levels of scrutiny to achieve its desired result. This term, it is easier for a state to survive strict scrutiny despite discriminating on the basis of race in college admissions than it is for the same state to regulate how abortion doctors and clinics operate under the putatively less stringent undue burden test. Likewise, it is now easier for the government to restrict judicial candidates' campaign speech, referring to the Williams-Yulee case, than for the government to define marriage, even though the former is subject to strict scrutiny and the latter was supposedly subject to some form of rational basis review. The bottom line, he says, these labels now mean little. The court should abandon the pretense that anything other than policy preferences underlies its balancing of constitutional rights and interests in any given case. Now, that's beautiful rhetoric, but what he's getting at is, look, it used to be that choosing the standard of review was itself the ballgame, and at least that was fairly transparent. But now the court has started tinkering, he says, with the tiers themselves and applying them differently, such that that threshold choice itself is no longer a meaningful constraint on judicial decision-making. Now, you can you debate whether or not he's right about that, but it seems to me that he is on the verge of discarding those tiers altogether. And I think, if I'm right, that that's the seed he's currently sowing, then that will be for him and for First Amendment jurisprudence, when he gets to the framework that he's going to replace it with, I think a fairly major shift in what folks are talking about when it comes to the First Amendment.
Thank you so much for having me today. It's really been great to hear my fellow panelists' comments, and thank you to the Federalist Society and the Claremont Institute for having me here today. Brian, in his introduction, was very kind in describing the panel, and he said there are 3 of us here who clerked for Justice Thomas, and 1 did not. You might have guessed from the fact that I clerked on the Ninth Circuit in San Francisco. I am the one who did not, and not only do I sit stage left on this panel, I also sit on the left side of the ideological spectrum. I am an originalist like Justice Thomas, but I am a progressive originalist. I believe that the Constitution was, at the founding of this country, a progressive document. Our arc of constitutional progress has only made it more so. The organization which I have the pleasure to lead, the Constitutional Accountability Center, is an organization that's dedicated to the progressive promise of the Constitution, and we use constitutional text and history and original meaning arguments in support of progressive outcomes. So, what am I doing here? Well, first of all, I will say that I have great respect for Justice Thomas as an originalist, and as going through my preparations today, I found something I wrote on February 24th, 2011, the title of which is Justice Thomas Emerges as Surprising Ally for Progressives. The first line is, yes, you read that right. But before I get into the areas in which we do have common cause, I want to say that, as Greg, I think, noted in the beginning, Justice Thomas's originalism on the court is something that is a little bit unique. Justice Scalia described himself as a faint-hearted originalist. I don't think there's anything faint-hearted about Justice Thomas's originalism. And while I vehemently disagree with him on many occasions on the outcome of his inquiry into the Constitution's text and history and meaning, I respect the methodology, and I think it allows for a conversation about these key constitutional issues that is productive and can be civil, because we're at least arguing on the same playing field. We're arguing over the meaning of the Constitution. And I thought it was telling when he gave this interview with Bill Kristol, and Bill asked him about his role in promoting originalism on the court and its acceptance in kind of public conversation about the law on the court. And he initially kind of resisted the label a little bit, saying he doesn't really think about that, he thinks about just getting to the right answer. But then he did come around and recount this conversation he had with Justice Scalia about how, because of basically the 2 of them as being the forefront of the kind of originalism on the court, that people look first to the text and history of the Constitution. Even if they're just going through the motions, they are at least looking to it, and he counted that as a victory. And so I thank him for that, because I also look to the text and history of the Constitution, and again, even though we often come to greatly divergent views on what it means, I appreciate and value that conversation. But as is suggested by my 2011 piece, there are areas in which I think that Justice Thomas's originalism has put him somewhat allied, and surprisingly allied, with a progressive view of things. That particular article was about his implied preemption doctrine. He sided with some of the more liberal justices in 2 particular cases, Wyeth versus Levine in 2008, and then in 2011 in the Williamson versus Mazda Motor case, in which he very closely allied with a brief that CAC filed, said that because the Supremacy Clause makes supreme the Constitution and federal laws made in pursuance thereof, this sort of freewheeling analysis into the purposes and objectives of federal laws through agency action, et cetera, cannot be used to displace state law. And the state laws in those particular cases were protective of consumers, something that a lot of liberal activists in the states are always trying to get passed by state legislatures. In Wyeth, it was a drug liability case. In Williamson, it was a motor safety issue. But what I really want to talk about, especially because this panel is about Justice Thomas being the lone justice, is one of, I think, his most admirable instances of being the lone justice, and that is in his vote in the McDonald versus City of Chicago case, which was, as Brian mentioned, about the Privileges or Immunities Clause. Well, I shouldn't say it was about that. I wanted it to be about that. It was about whether or not there's an individual right to keep and bear arms that is applicable against the states. I'm sure you all remember in Heller when the Supreme Court said that there was a Second Amendment right that protected against federal infringement on gun rights, individual gun rights. And this case was the follow-up case about whether or not there was an individual right that was protected against state and local infringement. Now, I should say that I disagreed with the Heller case because I think an originalist does not look at the Second Amendment and find that it's about individual versus structural rights. But I will say, as someone who takes seriously the text and history and original meaning, there is no question under the 14th Amendment that there is an individual right to have a gun for self-defense, because it is clear over and over and over, as Justice Thomas laid out very powerfully in his concurrence in that case, a concern for the ability of people to remain safe, particularly in the wake of the Civil War, where you had white militias in the South refusing to protect, and indeed quite the opposite, go in and affect racial violence against freedmen in the South. So to talk a little bit more about that, this case I thought was a really fascinating example of what an originalist does when a case comes to the court that presents an argument for original meaning that is in contrast with Supreme Court precedent. So the case comes to the Supreme Court, and there is an argument, of course, that the Bill of Rights, including the Second Amendment, which Heller construed to have an individual right to have a gun for self-defense, individual right. The Supreme Court has incorporated the Bill of Rights through, as we all know, the 14th Amendment, and the substantive rights through the substantive due process doctrine. Now, originalists like Scalia, in particular, have mocked this roundly, saying, how can you have substantive due process? So it presented a somewhat, I might say, awkward example of if you are someone who wants to support gun rights, which many conservatives do you then support the substantive due process incorporation right, or do you go with the privileges or immunities incorporation, which is what my brief, which was filed on behalf of scholars from all sides of the ideological spectrum, conservative, liberal, libertarian, said that when you look at the Constitution, when you look at the 14th Amendment, the Privileges or Immunities Clause is the way in which the drafters of the 14th Amendment envisioned the Bill of Rights and other unenumerated rights being protected against state and local infringement. That argument got one vote on the Supreme Court, even though I think pretty much every single constitutional scholar would agree that that is the correct way of looking at incorporation. And Justice Thomas wrote, in my opinion, a very powerful and compelling concurrence in the case, agreeing that the city of Chicago had violated the constitutional rights of Mr. McDonald, Otis McDonald in that case, and the other plaintiffs. And he did so by laying out a very clear history of the ways in which Representative John Bingham, Senator Jacob Howard, envisioned the 14th Amendment's Privileges or Immunities Clause as protecting individual liberties, individual rights, what they called the privileges or immunities of citizenship. And then, because I know time is short, I think one of the most interesting parts of that, because that had been written before by the scholars, many of whom signed on to our brief, but the way that he treated the two cases that basically strangled the Privileges or Immunities Clause in its crib in the post-Civil War era. He basically obliterates the Slaughterhouse case as being inconsistent just on its own terms. And then he takes apart the Cruikshank case. And not only does he say that Cruikshank got the meaning of the Constitution wrong and therefore is entitled to no precedential respect, and therefore neither of those two cases were impediments to restoring the original meaning of the Privileges or Immunities Clause. But I think it's very powerful that he says not only Does he reject Cruikshank because of the flaws in its interpretation of the Privileges or Immunities Clause? He would reject the holding because the consequences of Cruikshank warranted as well. And he has a very powerful invocation, I think, of Reconstruction and the period in which these great constitutional debates, these cases are being argued. He says, Cruikshank's holding that blacks could look only to state governments for protection of their right to keep and bear arms enabled private forces, often with the assistance of local governments, to subjugate the newly freed slaves and their descendants through a wave of private violence designed to drive blacks from the voting booth and force them into peonage, an effective return to slavery. Without federal enforcement of the inalienable right to keep and bear arms, these militias and mobs were tragically successful in waging a campaign of terror against the very people the 14th Amendment had just made citizens. So while Justice Thomas and I disagree on many of the outcomes of the constitutional debates over the meaning of rights protected, I take very seriously and greatly value his perspective on the importance of getting it right and the importance of noting when the consequences are not just wrong ideologically, not just wrong jurisprudentially, but mean that overturning that meaning of the Privileges or Immunities Clause meant that those who perpetrated the Colfax massacre got off scot-free. So I thank you for having me here, and I look forward to our conversation.
Well, thanks for those. Thanks to all the panelists for those thought-provoking remarks. I'll take this opportunity to invite our members of the audience to prepare to ask some questions. We have a microphone just to the right side of the room. We'll also have someone with a handheld microphone. And as you formulate your great questions, I will kick things off myself. So I guess I'll begin with a question that I think runs through the subjects covered by each of you today, and that is Justice Thomas's willingness to scrape away sometimes very long, very old lines of precedent and reconsider constitutional questions anew. Justice Thomas wrote in the McDonald case that stare decisis is, in his view, only an adjunct of our duty as judges to decide by our best lights what the Constitution means. And as I mentioned, this is not a practice that for him is limited to the correcting errors of the past 50 years. He has, for example, called for reconsideration of the court's 1798 decision in Calder versus Bull, among other examples of willingness to go really back to decisions not long after the founding. What is Justice Thomas's basic understanding of stare decisis, and is there a tension between his approach to stare decisis and his commitment to limiting judicial discretion in other respects?
I mean, I think his view, at least in constitutional terms, is pretty easy. So, I'll read this sentence from Kelo. When faced with a clash of constitutional principle and a line of unreasoned cases wholly divorced from the text, history, and structure of our founding document, we should not hesitate to resolve the tension in favor of the Constitution's original meaning. And you think, well, gosh, who could disagree with that? Of course, given a choice between the original meaning of the Constitution and a line of unreasoned and ahistorical cases, of course you would choose the former. It was a lone dissent. And so you might think, well, but there were other dissenters in the case, so surely what they did was they explained why the blight cases under the public use clause were actually reasoned or derived from the Constitution. They didn't. They distinguished them away because they didn't feel a need to attack those cases, but just to distinguish them. And I think that's the dominant mode of judging. This is Justice Thomas's view, which is that, when confronted with a historical meaning that he thinks is clear and a line of cases that don't adhere to it, he'll take the former over the latter every time.
Sorry. Yeah, I agree with what Jeff said. I think another way of thinking about it is that most judges who rely on stare decisis use it for certain purposes. It promotes stability or reliability, to adhere to old precedents. And I think for Justice Thomas, he does sometimes think that precedent is entitled to respect, but only if it's well-reasoned, right? Only if it's useful to helping the judge get to the right answer. And I don't think he has so much hubris to think that precedent can never help you get to the right answer, but where it's badly reasoned or, ahistorical, then it, out the window it goes. But I think that's a big difference in the ways of using stare decisis.
follow-up to that would be, I mean, there are some who would argue that stare decisis is itself a doctrine with some constitutional pedigree, that it is an incident of the judicial power. The judges should, in their role, in their constitutional role, have proper regard for past precedent. Does Justice Thomas think of stare decisis as something that is in some respects merely prudential or almost extra-constitutional, or does he instead regard it as a kind of constitutional doctrine?
I don't think anyone views it as a constitutional command. I mean, if it were a constitutional command, you couldn't have overruled Dred Scott.
I mean, you did have the 14th Amendment that helped overrule Dred Scott as well. But,
Couldn't have overruled Plessy. Could take your pick.
yeah, but I do think his point about, as Jeff and Nyomi have said, that the Constitution, even if stare decisis is a constitutional doctrine, the Constitution's words itself, have prominence over that, and sort of a supremacy clause within the Supreme Court's jurisprudence.
And I mean, by the way, the ad law cases are a great example of that. I used to joke when I clerked that Justice Thomas's view of stare decisis that he was only bound to anything that he had said before. But I don't think that's not even where he is. I mean, when I clerked for him, he was one of the foremost defenders on the court of the Chevron doctrine, along with Justice Scalia. And now you find him in the Michigan v. EPA case questioning whether the Chevron doctrine is violative of the separation of powers. So, I think even he would say that where he has re-examined an area and come to question what he once wrote or said, he has been entirely willing to go where that intellectual inquiry takes him, even if it's not what he's said in the past.
If we have audience questions, we can begin with that.
Thank you to all the panelists for your comments. If you had to pick one dissent or perhaps concurring opinion that you think, maybe not in the short term, but down the line, is there such an opinion that will one day become the law of the land, so to speak? Is there one opinion that the court will later adopt as having been correct, even though in the past it was a dissent?
It's a little hard to say, given the current uncertainty about the composition of the court.
Give us 2 weeks. No.
I mean, if Secretary Clinton becomes President Clinton and fills the open seat, I think that all of the opinions on federalism, on the Commerce Clause, the 10th Amendment, limited government, I mean, they're all out the window for a generation.
Questions to cheer us up? Professor Eastman, it looks like. Professor Eastman in the front here.
So I wanted to push back a little bit more on this stare decisis question. Brian, the way you formulated the question I thought was very interesting. Is there a constitutional aspect to stare decisis? And I want to challenge that because it really does flow out of, Elizabeth, the progressive notion of our Constitution, that the Constitution is whatever the judges say it is, right? And only if you accept that proposition do you get the notion that stare decisis is of some constitutional magnitude. The earlier version of stare decisis was, look, we can't revisit every question, every term, all the way. And when somebody has brought their considered judgment to it, we ought to give deference to that and respect, but only to the point where we have not become convinced of the error of the original decision. And it really, those two different views of stare decisis really do, I think, reflect the dramatically different views of the post-progressive era Constitution and the pre-progressive era Constitution. That's a question. Sorry.
Yeah, I mean, I feel honor-bound to say that I don't think that the vision of the progressive Constitution is that it means whatever judges say it means. I think that it means what the Constitution says it means, which I happen to think is mostly progressive. But if you look at its text and history, is extrapolated by wonderful scholars like Akil Amar and others. But I do think that's interesting, and I think perhaps it might cheer some people in this room in response to Greg's comment about if there is a change in the ideological makeup of the Supreme Court. I don't think it means that all of the precedents are out the window. I think that there is a respect for stare decisis, but I think I'm with Justice Thomas on this, that if there is a precedent that is so clearly in conflict with the Constitution's original meaning, particularly when it might stand for a kind of aberration from other respected Supreme Court precedent. I personally would put Citizens United in that camp, but I think his idea that our fidelity is to the Constitution, and when it's not in conflict, then of course we have these ideas of stability and protecting vested interests through stare decisis. I think that's legitimate, but I do think he makes a powerful argument for where possible. And he does go through, for example, in McDonald, he does say, I'm not convinced that these cases are impediments to returning to original meaning. So presumably there are cases that he might find provide legitimate impediments to returning to the original meaning. But where there aren't sufficiently good reasons, then I think he's absolutely right that we go with the Constitution.
Further audience questions?
This question is for the progressive originalist on the panel. I don't want to misquote you, but I think you said at the beginning of your remarks that the arc of our constitutional history bends towards progressivism. I think Justice Thomas might agree with you. He would just put a different value assignment on that. And I was going to ask, why do you think that is? And also, from what vantage point are you making that judgment? And the example that springs to my mind is the 18th Amendment, almost 100 years ago. Presumably the people who passed that thought that they were bending the arc of our constitutional history in a progressive direction, and I assume most modern self-described progressives would now say that was an aberration, it was very bad to do so. So are you saying that from the perspective of a 2016 progressive or some other vantage point?
Thank you. No, I think that it's written across the face of our Constitution. I think that's the glory of having the founders' wisdom of putting in the amendment process in the original Constitution, that we have, in my opinion, over the last several centuries, amended our Constitution time and time again to make it more inclusive, more equal, more just through the 13th, 14th, 15th Amendments, the 17th Amendment, which made our democracy more responsive to the people and was intended to root out political corruption. The 19th Amendment, the poll tax removing amendment, ways that included women, people of color, people of lower socioeconomic status in our society, and placing that clearly in the text of our Constitution. And so these aren't just sort of arguments about do the right thing. They're arguments of I am guaranteed this in the Constitution. And of course, as Justice Thomas himself has said, these promises were not always reality for Americans. I thought it was very powerful. He spoke at an event that my organization sponsored. He was in conversation with Akhil Amar at the National Archives and talked about growing up in the Jim Crow South and how he looked up to Frederick Douglass and the glorious, majestic guarantees of equality and liberty in the Reconstruction Amendments. But of course, they were, to invoke the words of Dr. Martin Luther King, promissory notes that were not cashed. And I think that is why I envision the Constitution as being progressive, not because of any sort of, shadows of penumbras, but because of the actual words that we, the people, have put into the Constitution over time.
Hi, my name is Elaine Middleman. Since this seminar is about Justice Thomas and 25 years on the Supreme Court, I was just wondering, what was his perspective when he was on the DC Circuit, and what is 25 years on the Supreme Court? Is it, I assume studying and giving a lot of thought to constitutional issues? Has he evolved in some way, or is he pretty much the same person?
Well, I was with him at the DC Circuit, so let me take a stab at this. I don't think he's changed very much. I think the willingness to stand alone as just an essential part of what he has to do to implement his oath, was there from the beginning. We started, he was confirmed in late October 1991, 2 weeks before his first sitting, which was the November sitting, coming in, brand new, 43 years old, thrown into the middle of this. His first sitting, he cast 3 votes as the sole dissenter. Only one of those cases actually came out that way, but he never, just never thought about, well, should I be with my colleagues? What will people think? He just called them as he saw them. I don't think he's changed much jurisprudentially. My experience with him was that he was always skeptical about Chevron, much more so than Justice Scalia. And actually, I think that's an interesting contrast between the two. Justice Scalia was Chevron's biggest advocate. Justice Thomas, I think in the opinion that Nyomi discussed, he's clearly saying not only is Chevron wrong, Chevron is unconstitutional. And the best that Scalia can muster in response, who is a great defender of Chevron, Scalia says, well, it produces certain insoluble anomalies, and it's inconsistent with the Administrative Procedure Act, but it may be consistent with how judicial review was done historically. Not exactly a ringing endorsement. And then on the related question of deference to agency interpretations of their own regulations, Thomas flipped Scalia on that. Scalia wrote Auer, which was one of the leading cases on deference to agency interpretations of their own regulations. By this last opinion, Scalia is saying Auer should be overruled. I think the one difference, which is one of degree, is that as he's thought about issues over the course of the 25 years, the ambitious opinions have become that much more ambitious. The opinion in women's whole health is really striking in that regard. He's taking on not only the specific question of res judicata that Justice Alito focused on, and not only abortion law writ large, which was what one might have expected from a Scalia dissent in this area, but the whole constitutional framework of tiers of scrutiny. I think something of that epic magnitude was a little beyond what you would have seen in October term 1991, but a natural outgrowth of all of these tendencies that we've been talking about.
So I'll add just one thing, which is, and I think Justice Thomas has said this, that when he first came on the court, he was very interested in the interplay between the Declaration of Independence and the Constitution and natural law and incorporation and privileges and immunities and all the rest. It's not to say he's not interested in those things, but he's now written on a number of them. He seems lately to be very interested in some of these structural and separation of powers principles. Now, my experience is very different from Greg's. My term, he wrote Brand X. 8-1 said that even if a court resolves the meaning of the statute, as long as it does it at the second step of Chevron, an agency can come in and say something different over a vehement dissent by Justice Scalia. So, he's now, it seems to me, very focused on some of these structural issues. And Justice Scalia used to say that those were his favorite cases on the court. And obviously, Morrison v. Olson is one of his most famous dissents. And so, I think there is a question now with Justice Scalia's passing whether Justice Thomas will be even more interested in some of these separation of powers issues and cases. He seems very focused on it in the administrative agency context.
I would also just add one other thing, which is I think over time, how have things changed? And Justice Thomas often says that, he now has a whole body of work, right? Works that his clerks have done, opinions that he's written. And I think now when he's writing against a background of a tremendous amount of research, not all of it which has made it necessarily into his opinions, but it's available for him to draw and build on. And I think that's a very different starting point from when he first came on the court.
Well, 25 years over the course of an hour was going to be a challenge no matter what, and I'm afraid we've come to the end of panel one. Ask the audience please join me in thanking our panelists for an illuminating discussion.